Hello, welcome to our micro seminar on the legal ethics of email. My name is Jason Castillo. I'm the Director of Legal Education with Attorney Credits. The purpose of today's micro seminar is to give you some issue spotting on issues you need to be aware of in regards to the ethics of electronic mail. Now, it's interesting to note that nearly 15 years ago, in an ABA informal survey, nearly half of the lawyers polled in the survey stated that they would never communicate with their clients via email. So you can see how far we've come in such a little time. In a little over 15 years, we now communicate with clients, courts, other attorneys, all via email. This has become a very popular communication medium amongst attorneys and people in general. Obviously, there's billions of emails sent every day. So the question for you to consider is, under ethical auspices at least, is sending unencrypted email violate your duty of confidentiality in the state in which you may practice? Now, at the national level, we have the ABA model rules. At the state levels, that's what you really want to be concerned about. However, the wording and the rules are all generally the same. The wording in the rule is to protect client confidences, not to reveal information relating to the representation of the client. However, this can be a heady task in our new digital times. A new communication medium like email, it's very easy to disclose client confidences, or at least much easier than in the past when things were kept under lock and key in file cabinets. Now that things are kept on networks and people send emails across continents, the leak of confidential information is much greater. So turning first to the national level, we have ABA Formal Opinion 99-143, written about 10 years ago. 4 main points to this opinion. The first point, yes, there is a reasonable expectation of privacy in email. Secondarily, attorneys don't necessarily have to encrypt every electronic communication sent, every email sent to every client. Third, just as a phone line can be intercepted or wireless communications can be eavesdropped, there are other communication mediums that have problems as well, not just email. And then lastly, and probably one of the key takeaway practice points, opinion 99-143 from the ABA states, talk about it with your client. Just discuss it up front with them, maybe in the fee agreement when you first down and sit and meet, or you're going to get a sense. Obviously, if you're an estate planning attorney and you have a client that's 85 years old, that's not going to be the same as if you're a business attorney, you work with young tech individuals that are maybe starting companies. So again, the sophistication of your client will greatly determine whether or not email is a good method of communication. And what a lot of these cases do tend to come down to is the reasonable expectation of privacy that attorneys do have in emails. And there was a main case that came out of Delaware, and that's opinion 2001-2, where the committee eventually concluded that there is a reasonable expectation of privacy in emails, and that attorneys do not violate their duty of confidentiality by sending unencrypted emails. And that, again, is in absent extraordinary circumstances. Context will be key. Maybe if you're emailing a client on where to meet for lunch to discuss the details of a case, as opposed to sending an email detailing the billion-dollar settlement talks on a government case. Again, that's going to depend upon what level of security you want to use. So a few areas that we have to be aware of, and what I'm going to cover for you right now, where you need to be concerned about the confidentiality of your information in the email, one of which would be hacking. The secondary grounds would be inadvertent disclosure, just basically sending the email to the wrong address. Screenshots, that's a third area that attorneys have to be concerned with. And then lastly, attachments and metadata, hidden information that you don't even really know exists in the email. So let's get to our first point of where your information can be compromised, and that's hacking. And the word hacker seems to imply some pimply 16-year-old face, kid sitting in his parents' basement on a Friday night, hacking into the school systems or maybe a local bank. Well, that's no longer the case. Hacking is now run by sophisticated Eastern European criminal rings, Russian mob and such. But maybe these aren't even the hackers you have to be aware about. For example, when you do send an email, it sits in somebody's inbox. There was a case in West Virginia, I believe 2006, West Virginia versus Markins, brings home the real-life aspects of email and how that information can be compromised. It involved a husband and a wife both of which were attorneys in West Virginia. Now the client or the husband became suspicious that the wife was taking client satisfaction to a whole new level, if you get what I mean, and became suspicious that the wife may have been cheating on the husband with one of the clients that the wife represented at the firm. So the curiosity got the better of the husband, who then started going into the wife's confidential firm email, opening up emails, reading them, opening attachments. But he didn't stop there. He also checked email of other partners, other people at the firm. So this turned out to be a major problem for the firm. They eventually discovered that it was the husband, and the husband was suspended from practice for 2 years once this was all uncovered. Secondarily, another way that confidential email or confidential information in emails can be compromised, violating your duty of confidentiality, is inadvertent disclosure. And that's just simply checking the wrong address box when you send out that email. There was a case, I believe a New York litigator, very well-known prominent litigator, was a bit upset with a settlement that was reached with one of her clients. So she internally circulated a pretty negative email, which had some pretty bad insinuations about a state attorney general. And while she intended to circulate this email inside the firm, unfortunately for her, she checked the wrong box and ended up sending it to a reporter. So you can see there where it wasn't such damaging information, maybe embarrassing for her, but again, you could see where confidential information could definitely be lost. There was also another Philadelphia litigator who intended to email a co-counsel named Berenson. This is a separate case, but instead of checking the right Berenson, this attorney checked the Berenson of a reporter that was in the address boxes. So again, instead of sending out a confidential email to another attorney that was talking about billion-dollar settlements in a government pharmaceutical case, this attorney sent this email out to a reporter, again a New York Times reporter, and it was then posted in the New York Times. So again, you can see where this can be embarrassing, and it could definitely lead to an ethics violation and possibly malpractice sanctions. The third area that we have to be concerned with is screenshots. Something that not many of you know, a very technical thing. Screenshots, basically every time you visit a web page, any web page you visit, there is a shot, an internal screenshot taken by the hard drive of your computer and stored in a temporary file. So all of your internet voyages are documented somewhere inside your computer. Welcome to the days of ESI. Well, there was a case, I believe, in Massachusetts, NERA case, NERA versus Evans, in which a gentleman worked for NERA. He was a consultant. He was leaving the firm. He took every level to wipe off all the information off the computer. He took it to a technician. He turned the laptop over to the firm, which then took that computer and mined it for digital information. And some of those informations were conversations that had taken place between him and his attorney, confidential client communications, that this firm went in and mined. And it was held that they were not allowed to use these communications because a reasonable person doesn't know that these screenshots exist, and nor do they know that they can be used against them. But again, something that you need to be aware of. And then lastly, our last issue is hidden information involved with emails, and that would be concerning metadata and attachments, because there is a lot of hidden information that you send off that you don't even know that's there, or it might not even be there. For example, if you took a document, maybe you're working on contract revisions, you were going to send it to an attorney you were working with, or an opposing attorney, and you attached a document and then realized you needed to go back and change some numbers, so you unattached it, and then you took that document and reattached it. Well, the one that you unattached, that is physically still there. It might not be there, it looks like you've deleted it, but with a little bit of work, a forensics examiner could go back, take the email, and the email that you unattached and you thought you removed, they can get that email. So they could take the 2 copies of the contract and see how you revised the contract. Well, these are just some of the issues and issue spotting that I want you to be aware of in our digital age. My name is Jason Castillo. This is our micro seminar on email. I'd love to hear from you. My email is jcastillo@attorneycredits.com, or you can also check out our blog. We're also on Facebook as well and LinkedIn. Thank you very much. Have a great day.